Major breaking news. The United States Supreme Court has granted cert in the Vanderstok versus Garland case dealing with quote-unquote ghost guns. Specifically, the ATF has tried to expand the definition of what is a frame or receiver and expand the meaning of so-called weapons parts kits to encompass things that are not firearms and yet claim they are firearms. This should be a major win for the Second Amendment and for the do-it-yourself gun community, which is an extremely part of the Second Amendment community, because that is part of the community, of course, that has no obligation to undergo background checks and thus cannot contribute to a potential national gun registry. Stay tuned. We're going to break down this big news out of the United States Supreme Court today. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many Second Amendment books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, we got to get right to it. Major breaking news. U.S. Supreme Court has granted cert in the Vanderstok versus Garland case. You may recall this. This has been a major fight around the country, and this is also the case which we covered about a year ago, maybe not quite a year ago, where the Supreme Court denied or granted administrative stays in favor of the ATF. There was victories on behalf of gun owners in the Vanderstok case down there in the United States Court of Appeals for the Fifth Circuit that arose from cases out of the state of Texas in federal court there. There was a series of rulings in favor of essentially the Second Amendment, although technically speaking, it was really against the ATF's power. So technically speaking, this Vanderstok case is not a Second Amendment case. It is a gun case, but it's not a Second Amendment case. But it does speak to the Second Amendment because it speaks to ATF overreach. Now, if you may recall, there was a series of victories against the ATF out of Texas and the United States Court of Appeals for the Fifth Circuit. The Solicitor General, Merrick Garland, the Attorney General and his Solicitor General sought basically to stay the rulings in our favor to prevent them from going into effect. On two occasions, the Supreme Court, and both occasions, granted the stay, which is not unusual that they give this deference to the Solicitor General's office and the Department of Justice. It's one of those unfortunate facts. But now I don't think that impacts the merits of this case. They've now granted cert, and here we are. Now, the question presented in this case, as you may recall, is this was an attempt by the Biden administration to skip over Congress and crack down on the so-called do-it-yourself gun market by redefining items that require massive amounts of substantial work to somehow convert them into something other than a gun, into a firearm. And this includes the definition or the expansion of the definition of firearm in two ways. One is it says that anything that is a frame or receiver, and here's the key part, that's fine because, as you know, a firearm under federal law is defined as the frame or receiver. Usually the frame goes with the handgun, the receiver usually goes with long guns like AR-15s. And what happened here was ATF said that not only are frames and receivers firearms by virtue of our regulations, things that are readily, hear what I just said, readily convertible into frames or readily convertible into receivers are also now firearms. So basically, this is not going to work, I think, statutorily, because if you look at the Gun Control Act of 1968 and how they define firearms, they specifically say, and here's the key language, that it's any weapon which will or is designed, and here's the key phrase, or may readily be converted to expel a projectile. So you saw that in the Gun Control Act, the definition of firearm, when they're talking about any weapon, it's any weapon that will or is designed to expel a projectile, or any weapon that, quote, or anything that, quote, may readily be converted into that kind of a weapon. But here's the key, that's subsection A. But then when you look at subsection B, which is the relevant provision dealing with Vanderstok here, it talks about specifically, quote, the frame or receiver of any such weapon. So what the ATF and Joe Biden did is they played games, of course, is they took that phrase from Clause A of may readily be converted, and they cut and pasted into Section B as if it were there by Congress, but it's not. So what they're now saying is that a frame or a receiver or anything that may readily be converted into a frame or receiver is now a firearm that requires the undergoing of a background check and requires anyone that sells something that could be readily converted into a frame or receiver to somehow have to go through a background get background check or become an FFL and conduct background checks. This is clearly not appropriate as a matter of statutory law, because it shows that ATF again is engaged in massive overreach because they cannot get their gun control laws through the Congress. Now, I want to point this out. I've used this metaphor before. You know the old saying that says, taste like chicken? I've always taught you that if somebody says that tastes like chicken, it means it's not chicken. It's like chicken, okay? Likewise, if I say to you, that painting is like a Rembrandt, or that painting is like a Picasso, it's not a Rembrandt, it's not a Picasso, it's something else. So here, what you have is the ATF trying to say that a frame or receiver under the statute is a firearm. And it's also a receiver under the regulation is also a firearm. But here's the sleight of hand. They then changed the regulation to say that anything that can be readily converted into a frame or readily converted into a receiver is also a frame or receiver, and thus by extension it's a firearm. But that is analogous to the reasoning, and I think you'll see this argument for the Supreme Court that basically goes like something that is like a frame or like a receiver is not a frame or receiver, in the same way that something tastes like chicken is not chicken. So that's going to be a big part, and I think as a matter of statutory law, we're going to be fine. This is a very good news because, again, Biden is trying to destroy the do-it-yourself industry and force everyone in America that wants to acquire, make, or deal with firearms to go through a federal background check in an attempt to create a national gun registry. Now, I don't think it's going to work for a whole host of reasons as a matter of practicalities, but this is the goal. They want to make sure that every gun owner, that every gun, that every bullet, anything they can do, they want to have some sort of records on it so they can compile this list, which is illegal under federal law. But the one thing about the Biden administration is they will redefine everything so that anything that is illegal is now legal. Anytime they're not allowed to forgive student loans under the statute, they will find a way to forgive student loans under the regulation if it helps their team. When we don't have to get through the testimony about what is a woman by Justice Brown Jackson to show the attempts to redefine terms in American life by this administration. So again, this is specifically an attempt by the Biden administration to broaden the definition of what a firearm means under the Gun Control Act by expanding the definition from frame or receiver to something that's like or readily convertible into a frame or readily convertible into a receiver. So there you have it. What does this mean? I think this is ultimately good news. I think despite the fact that the administrative stay was granted a couple times in favor of the ATF, I think they're not going to win this case. I think we're going to win this case. The ATF will lose. And this will be one of the gun-related cases before the U.S. Supreme Court in the term 2024 through 2025. The briefing should all go in over the summer. Sometime the argument will be had, I'm guessing, probably in the month of October 2024. And what does this mean for the Bianchi and these other Second Amendment cases? These are all still pending. The Supreme Court has plenty of time to take additional Second Amendment cases. We'll see what they're going to do. And again, technically speaking, the Vanderstok case is about regulation, administrative law, and the growth of the deep state bureaucracy over the elected officials, because this is basically an attempt by Joe Biden to enact legislation through ATF fiat or ATF regulation rather than going to Congress and trying to pass a law if they could, because of course the Biden administration's policies on guns are extremely unpopular and will not get through the Congress because they haven't got through the Congress, with the exception of the turncoat John Cornyn, who did that back in 2022 with those slight changes to aspects of the gun control laws. But nevertheless, we don't need to get into the traitor John Cornyn when it comes to disrespecting our Second Amendment rights. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X for more Second Amendment news at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.